within 2 hours or something like that,
Yeah.
right?
Hmm.
Do you expect more because these investor type programs? There used to be a big federal one years ago,
Hmm.
but it seems like there are less and less programs like this, even entrepreneurial programs that require a person to deposit a certain amount of money and start a business and that type of thing. It seems like um, more of those programs, and of course, more of the provincial and federal programs are moving away from passive investments.
Yeah.
And do you agree with this, and why do you think this is?
So I think they've realized, and they've been pretty interesting studies showing that a lot of the people who come in as investors, and they're not required to open a company or anything like that, they come to Canada, they get their PR, they keep their money abroad and tax havens and things like that. They get the citizenship and then they leave. So we thought, I mean, so the government, yeah, they get 1.2 million or whatever it is, $800,000 that they get to invest interest free for 5 years, but that's mainly it. So I think the governments, the different provinces and the federal government has determined that, I mean, doing an interest-free loan, I mean, it's helpful, but it's not as helpful as bringing someone who's making a commitment to open a company and then hiring Canadians and providing something more to labor market. So I think that's why they've moved away from passive investment. And even more interesting, they moved away from you provide a business plan and we give you permanent residence. Now what most provinces are, okay, you provide a business plan and we give you a work permit and you have 2 years to open the company, hire the people that you said you were going to hire, invest the amount of money that you're going to invest, and then you get permanent residence. So again, I think it's smart. Obviously makes it more difficult for prospective immigrants, but if we're thinking about the Canadian economy, I mean, that's better than just buying your citizenship, which in a way could be seen if you're just doing a passive investment.
Yeah, and I think they had a study a while ago, or maybe just a newspaper article that measured the tax returns
Yeah.
of those investors and compared them with every other demographic, really, of immigration, and they found that they were by far the lowest tax-paying
Yeah,
immigrants, right? So
yeah,
even
that's
people
correct.
who, yeah, it was something like even students paid more taxes,
Yeah,
even refugee
people
claimants
coming
paid
as
more
refugee
taxes.
claimants. Yeah,
That's
exactly.
it. So I think maybe they were a bit maybe naive or something like that in thinking that it would attract like the cream of the crop of entrepreneurs and those types of people who'd come here and start businesses and that type of thing. But it seems like it just didn't work out at all.
Yeah, for sure. And I think that's why we see that move there. Um, and I mean, and Canada is just like moving, like Quebec is the only one that's really left with like passive investment. Okay, so the other important developments that we've grouped, we really didn't have a category where we could all put them together, so we kind of like grouped them into one. The first one is mainly suspended programs. So one of them I'll cover quite quickly. I mean, there's the self-employed program it's a federal program, one of the economic programs, not federal school worker or any of those. It's for self-employed people, and it's under three branches. So one of them is artists, one of them is athletes, and the other one used to be a farm management stream. So if you were able to show certain years of experience managing a farm, like 1 year in the last 3 years, and you were coming to manage a farm in Canada, you as a self-employed individual, so your own farm, you were able to navigate this self-employed program. It was a point system in the sense that you had to reach certain points to be able to qualify, like the federal skilled worker, but it wasn't too competitive to be able to qualify. And then the government suspended it as of March 10 of 2018. I think part of I mean, the processing times were ridiculous. Like, I mean, we're looking at like 5-7 years, a lot of refusals on the program, and I think a lot of abuse too. A lot of people just like had like fake documents about their farm and like claiming that they were running a farm and things like that. So I think the government just decided to put an end to that. And I mean, if some people really have a successful management operation of a farm, they could always navigate the PNPs. There's two provinces, Saskatchewan and Alberta, that have specific programs for farm managers, and then you could technically navigate one of the other provincial programs. But the federal self-employed program for farm management was suspended. And quite frankly, I've never been very fond of the self-employed programs at the federal level. Advising, it's always the last resort in my case. because they're very long to process, and they have a lot of like bureaucratic hurdles. And then sometimes, I mean, they might be the only option for some of your clients, let's say an athlete or an artist that is not competitive under one of the other programs. But I mean, I think they're kind of like on their way out, and we already saw it on the farm management one.
And when a program is suspended like this, is that usually the first step to closing the program permanently, or is there maybe potential in the future for the program to come back?
So I think a bit of both, right? Sometimes you find, like for instance, the PR path to caregivers, which we're going to be talking about next. I think it's been suspended because they're reevaluating it, but they're going to open it again. The government has even said that they are looking into another pathway for permanent residence. There are others that you know that they're done. So a good example, you were talking about the federal investor program. Canada used to have one at the federal level. They paused it. They introduced a new pilot one, which they realized was not working, and now they they eliminated it again, and we don't know whether they'll introduce a new one or not. With the farm management, I didn't really do applications under that program, but I knew a lot of people who had gotten refusals, and I know there was a lot of abuse. It's also, if you think about it, there's a lot of people who run farms in India and Pakistan and like a lot of like developing countries. They don't have a lot of documentation of that, so it was very difficult to prove this. So I think it might not come back, or maybe if the agricultural economy is very important to the provinces, I would see them more jumping in to create these opportunities rather than at the federal level.
Yeah, exactly. And I think I read an article that one of the visa processing centers had something like a 99% rejection rate of people applying under this program.
Yeah.
Because you had the classic, maybe a corn farmer from India. Will he be able to grow wheat in northern Saskatchewan, right?
Yeah.
So
Yeah,
there was
that's
a
a good
bit
point.
of, I think they were looking at it a bit superficially and saying, oh, a farmer's a farmer, but yeah, it's a pretty detailed job, and it's quite different going from one country to
Yeah.
another, especially if you're going to survive those Canadian winters.
For sure. And as immigration practitioners too, it's very frustrating to put all that effort, have a client pay you, navigate it for 5 years and like responding and having your client do like exams and all this different thing, medical exams and things like this, and then getting a refusal, right? So I mean, again, it wasn't like a big part of our practice. I never did one under the farm management stream. It's not like I feel it's a big loss for a lot of us.
Yeah, I agree, and I think with it goes back to what we talked about right at the beginning, which is that the study option is always such a great option to
Yep.
present to your clients
Hmm.
because when you look at the wait times for these self-employed artists or something like that, I know the wait time used to be 8 years, 6 years. I think I read that it dropped a little bit recently, but in those, let's say it's 2 years, and those 2 years you're waiting for a response to that application. Well, if this person had decided to come as a student, the person would have been here way sooner, working,
Yeah.
studying, transitioning to PR. So it's when you're trying to present that to clients, that's the way that we go with it. Though I would assume you might have some clients who either they hear kind of that it's going to be such a long wait time and they just lose interest, or they just kind of do nothing.
Yeah, for sure. And I think it's fair that the clients, if it's something that's going to be 6 years, that they're not just waiting that long to get a refusal, they might as well just go for alternatives before. And as you're saying, even if they were considering studying, it's good that they considered it 5 years ago when they could still be competitive in age after graduation than 5 years later. Okay, and then the other suspension, which is quite a significant one, is the PR path for caregivers. So in February of this year, we got an announcement that the 5-year pilot program that was instituted in 2014 is under review and will expire November 29 of 2019. Okay, so we knew there was a 5-year pilot program. We knew that the government had changed the former living caregiver program to a program that has it's a first step LMIA for either child caregivers or for those who are providing caregiving to those with high medical needs. So it could be nurse aides or home support workers. And there's also like nurses, like registered nurses. And yeah, I mean, there used to be a path where, okay, you've worked in Canada for 2 years for an employer, normally the employer that got the LMIA, and then you can transition to PR. And now they said that it's been suspended. So interesting enough, we anticipated this. Remember, we were talking about when we looked at the immigration targets at the beginning of the year, we saw that in 2020, there was no space for these people. So what is the government planning on doing? Are they canceling the program of 2019? And eventually they decided to suspend it. And as we talked about with Kyle earlier, this is particularly troubling for people who are child caregivers, nurse aides, and home support workers. We're looking at NOCs that are 4441, 4412, and 3413, NOC level Cs, right? So people who are not going to be able to do a CC application, they could be very young, very good English, excellent educational credentials. It doesn't matter. You cannot access any of the federal programs for skilled workers because it's not considered skilled occupation. So what's the alternative? We have them here. A lot of them gave up jobs in a different country. They could have gone to Europe. Could be someone from the Philippines who could have gone to Europe, could have gone to the UAE, to other places to come to Canada with the guarantee that if they do their work, they're going to be able to transition to PR, and no longer. So not good news for a lot of our clients who we've done LMIAs under those. And then we'll have to see how the government responds. Now, a good thing was that the day that the announcement came out, or a couple of days later, the minister said, government is committed to ensuring that caregivers continue to have a pathway to permanent residence. So at least we know that there's that intention, at least from the Liberal government, but we'll have to see whether that is. It's not in the immigration plan. For 2020, it's not there in the numbers. We'll see what they come up with, and maybe the provinces will jump in. We saw that Ontario jumped in for the skilled trades people. They jumped in for people with in-demand skills. Maybe many provinces will come up with their own caregiver category, and that would kind of, which is a smart thing to do. They are in high demand and low supply, and then you can transition them if they've had that employment in the province, or maybe they still have that employment in the province. We'll have to see what happens, but it's definitely troubling for some clients.
Yeah, that's a real great comment about the provinces maybe taking the lead on this. I remember a few years ago, it might be 5 years ago, 6 years ago, Alberta changed one of their PMPs to allow low-skilled workers to obtain PR. I remember because I was working for IELTS and we flew out there to do thousands of exams because this program was just going to be open for, I think it was 6 months or 3 months or something like that. And yeah, it was because of a federal change, and they reacted in this way because they found that, of course, they had the demand. They had all these English-speaking workers, really, and they moved really quickly with it. We were all surprised, actually, in the IELTS world as well, because we had to do so many exams so quickly. And I hope, actually, they do something like that as well, because if you meet caregivers and that type of thing, they're just fantastic people. A lot of Filipinos are in that kind of that area of work as well. And if you ever, I studied a little bit of this because I worked in the Philippines. I took a business trip out there. And yeah, Filipino integration in Canada is just huge. I mean, the whole population of English-speaking, hard-working people, right? So it's, I think, I agree with you completely. I hope that's the move that they do, and it would benefit really everybody.
Yeah. This is something, I mean, we'll have to see what happens next year, and hopefully it's an announcement soon, right? Because I mean, if you're bringing clients right now with an LMIA as a caregiver, you have to, I mean, have that discussion from the beginning that okay, we might be able to come as a temporary worker, but how are you going to transition to PR? And before we could make this pitch to them, we can't anymore without any guarantees that the government's going to do something. Not to mention that when you apply for the work permit, in the intention to ties to home country, we always said, well, if this person does the 2 years, there's a PR path for them, so they're not going to be overstaying in Canada. We can't make that argument anymore. Okay. I think 3 more things that we want to point out. One of them is the biometric expansion. It's pretty straightforward, but significant in the impact that it's going to have on clients. So starting on July 31st of this year, Canada expanded the biometric collection to everyone who was applying for a TRV, study permit, work permit, or permanent residence and refugee protection from Middle East, Africa, and Europe. So if you're applying from those countries, you need to provide biometrics. So go get your photo and your fingerprint. And this is spanning throughout the world. December 31st, 2018, supposed to hit Asia, Asia Pacific, and the Americas. We have a very special relationship with US citizens. They're exempted from a lot of things like the ETA, like getting, they can apply for study permits at the border. They're going to be exempt from biometric collection. Again, we have like very good, or at least used to have very good relationships with them and their previous governments. And there's exemptions so far for in Canada applicants, but this exemption is no longer going to apply once there's going to be specific Service Canada locations where people can provide biometrics. If you're eligible to apply for, let's say, a work permit at the port of entry, then you can provide biometrics at the port of entry as well. And that's something that's expected to continue to exist then. So again, something important to warn clients about. This is particularly problematic, and I'm going to give you the examples. If you have someone, and this is a very common scenario that I'm sure you've experienced it many times, Kyle. You have someone in Canada, let's say it's an European citizen, a Greek citizen, who's here and is applying for a work permit or a study permit, but it has to be an out-of-country application because they're here as a visitor, or they're not eligible to apply within Canada. Well, before you would do an out-of-country application, it doesn't matter that they're here. It's processed online, it's approved, they can go to the border, get their work permit or study permit, and then re-enter the country. Now they have to give biometrics. And since there are no centers to provide biometrics in Canada, we've had some applicants like that they have to like fly to the US if they have a US visa, or go somewhere else to be able to provide biometrics. So those we've seen difficulties with. One of them was, for instance, a client that was here working, but he wanted to apply for a Francophone work permit. And you can't apply for those work permits within Canada the first time. You have to do it outside of Canada. So we'd send an outside of Canada application explaining our client is legitimately in Canada, allowed to be in Canada, and they said no, he needs to provide biometrics because he's an African citizen. So he had to go to the US to provide the biometrics. And another interesting case that we had was someone who lives, I think it's St. Kitts. No, let me think. No, St. Martin. And he was a European citizen, but he was not living, he was not living in Europe. So he's a European citizen because everyone there, they're European citizens, but he was living, but he was not living in Europe. And since he's a European citizen, he was required to provide biometrics, and there's none in his country. So he had, like, the closest I think was St. Lucia to be able to do that, and he had to make the trip to be able to provide biometrics. So these are kind of like some practical problems that arise by the fact that there's biometric requirements, but not the centers to provide them. Important to know that if you're applying for a visitor visa, work permit, or study permit, you only need to give biometrics every 10 years. So if you came as a student and you provided biometrics 3 years ago, you don't have to give them as well. Unless you're applying, if you did have a refused application, you need to provide biometrics again. I'm not sure why they're doing this, other than to punish those who had refused applications, but you might have applied for a TRV 3 months ago. If you're applying again, you have to give biometrics again. The every 10 years, I think it makes sense. I believe that there's biological reasons for this, like your prints change over years. So like your prints might not look the same after 10 years, so that's why they're doing it. And if you're applying for PR, regardless of when you gave biometrics, you have to do it again. And again, they're gonna have the possibility to do it within Canada as of next year. We're gonna get a little bit into like jurisprudence now. Anything else that you wanted to add, Kyle, about biometrics or the programs that were suspended?
No, just in terms of biometrics and people here who kind of get into those tricky situations. That's why I always love having clients in another country where you start everything sort of as a fresh slate rather than somebody in Canada, because a lot of people as well, they think that they'll come here as a tourist and then transition to maybe a work permit and then PR and then citizenship. But it's much easier, of course, just to start the whole process overseas.
Yeah, for sure. And again, so like it's an extra consideration that you have to, at least for now, discuss with your clients if they're here, because there's no way to provide biometrics here. Okay, so we wanted to end with two. I mean, I think neither Kyle or I are like the experts on litigation. I mean, even though I'm a lawyer, I don't do the litigation at my firm. Other people do it. But there were two significant changes, one in the legislation and another one in at least like a really important Supreme Court case that came out last year, which is worth discussing. So one of them is Tran versus Canada, which has to do with conditional sentences and serious criminality. This was a question that we had for a while, right? If you are convicted of what's called serious criminality, you can be removed from Canada. So you can be deported from Canada. Let's say like you're a permanent resident, you can be removed from Canada. But there was always the question of whether a conditional sentence, so basically again, house arrest, could be trigger this type of conviction that would warrant a removal. So I'll provide the facts, the questions that the Supreme Court was investigating, and then what they concluded. So we have a foreign national, Tam Tran, who was a permanent resident in Canada, and he was convicted of operating a large marijuana grow operation, something that is no longer criminalized but was back then. And the maximum, so there's two interesting things here. So one of them was that the maximum sentence for the offense was 7 years at the time of the offense, but it changed to 14 years at the time when he was convicted. So that's one thing. The offense, the time for the offense, the maximum penalty for the offense changed during the time that he committed the offense and he was convicted. And then the other interesting issue is that he received a conditional sentence. So he did not receive a prison sentence. He was not sent to prison, but he was given, let's say, house arrest, a conditional sentence of imprisonment. And then the IRB had to determine, because he was a permanent resident and not a citizen of Canada, whether his conviction should result in a removal for what's called serious criminality, right? So they're looking at Section 36 of the Act and trying to determine, does this trigger serious criminality? Is a conditional sentence of imprisonment a term of imprisonment under Section 36(1)(a) when assessing PR inadmissibility, right? And the reason they're doing this is because under the Act, if you're convicted of an act of serious criminality that carries a prison term of more than 10 years, then you could be removed. So two interesting things here. If you're convicted for conditional sentence, does that mean carrying a maximum prison term of at least 10 years? Of a prison, is that the same thing as prison term? And the other issue is, okay, it was 7 years at the time of the offense. That was changed to more than 10 at the time of the conviction. How do we treat this? So the Supreme Court was tasked with two issues, or investigating two issues, or determining two issues. First of all, is a conditional sentence of imprisonment a term of imprisonment under Section 36 of the Act? And does the phrase punishable by a maximum term of imprisonment of at least 10 years refer to the maximum term of imprisonment at the time of the offense or at the time that they're making the admissibility decision? Okay, because obviously the offense was at some point, the IRB was looking at admissibility later on. And from the perspective of the immigration practitioner, both answers were good to us. So the answer that a conditional sentence does not constitute a term of imprisonment. That's huge. That was like, again, a big debate. A lot of cases were based on this thing. You had clients who agreed to something with the Crown, but they gave them house arrest. They gave them conditional imprisonment. Is this going to be a problematic or not? So we needed that answer. Does this constitute prison or not? And they said conditional sentence are not necessarily serious criminality under IRPA. It does not constitute a term of imprisonment. Basically, I mean, the way that the Supreme Court arrived at this decision is that they said that the length of a sentence alone is not an accurate yardstick in which to measure the seriousness of the criminality of the permanent resident. So basically, if a judge decides to sentence you to house arrest instead of imprisonment, that should be taken into consideration, not just the length of the maximum penalty. And the meaning of term of imprisonment varies according to the statutory context. So the Supreme Court noted that there's no consistent meaning of what imprisonment entails. So that was the first good news. Conditional sentences do not constitute a term of imprisonment. And then the second one, which has a lot of applications to other situations, is that deciding whether a PR is inadmissible to Canada depends on the maximum sentence at the time that they committed the offense and not when their immigration proceedings begin. So if I committed an offense that's 5 years, and this is going to be important because of like the dangerous driving offenses and how it's gone from 5 to 10 years. So if I was convicted of drunk, I don't know, like dangerous driving, I had alcohol and I drove and I was caught. And then I have an admissibility hearing at the IRB. The IRB is going to be looking at the penalty when I committed the offense, not when they're having that admissibility hearing. So it's not at the time that the IRB is studying my case, it's not at the time of conviction, it's at the time that I committed the offense. So those were the two tenets of law that we get from this decision.